Protected classes refer to groups of individuals who are safeguarded by anti-discrimination laws and regulations, which prohibit discrimination against them based on certain characteristics or attributes. These laws are intended to promote equality and prevent discrimination in various aspects of life, such as employment, housing, education, and public accommodations. The specific protected classes can vary depending on the jurisdiction and the specific laws in place, but some common examples include 1. Race and ethnicity. Laws protect individuals from discrimination based on their race, ethnicity, or national origin. This includes people of all racial and ethnic backgrounds. 2. Gender. Discrimination based on gender, which includes discrimination against women, men, and individuals who identify as transgender or non-binary, is typically prohibited. 3. Religion. People cannot be discriminated against because of their religious beliefs or practices. This includes individuals of all religious faiths and those who do not adhere to any religion. 4. Age. Age discrimination laws protect both younger and older individuals from being treated unfairly in employment, housing, and other areas because of their age. 5. Disability. Individuals with physical or mental disabilities are protected from discrimination and are entitled to reasonable accommodations to ensure they have equal access to opportunities and services. 6. Sexual orientation and gender identity. Many jurisdictions have laws that prohibit discrimination based on sexual orientation and gender identity, ensuring that LGBTQ+ individuals are protected from discrimination. 7. Sex. Laws prevent discrimination based on sex or gender, ensuring equal treatment for men and women. 8. Pregnancy. Pregnant individuals are protected from discrimination in employment and other areas, ensuring they are not treated unfairly because of their pregnancy or related conditions. 9. National origin. Discrimination based on a person's country of origin or ancestry is prohibited to ensure that individuals are not treated unfairly because of their heritage. 10. Military status. Some laws protect individuals who are members of the military or veterans from discrimination in employment and other areas. 11. Marital status. Discrimination based on whether a person is married, single, divorced, or in a domestic partnership is prohibited in some jurisdictions. 12. Genetic information. Laws protect individuals from discrimination based on their genetic information or family medical history, particularly in the context of healthcare and employment. These protected classes are established to promote equality, diversity, and inclusion in society by preventing discrimination against individuals based on inherent characteristics that are unrelated to their abilities or qualifications. Anti-discrimination laws and regulations vary by country, state, and municipality, so it's essential to be aware of the specific protections provided in your local jurisdiction. Violating these laws can result in legal consequences, including fines and penalties, for individuals and organizations that engage in discriminatory practices. In passing the Fair Housing Act in 1968, Congress established a national policy to provide for fair housing throughout the United States. This act and other federal fair housing laws prohibit discrimination in the housing market. It's important that real estate professionals be aware of all the laws and regulations governing any real estate transaction, be it on the buyer or seller side. The Fair Housing Act declares a national policy of fair housing throughout the United States. The law makes illegal any discrimination in the sale, lease, advertising, financing or availability of housing based on race, religion, color, sex, disability, familial status, national origin, sexual orientation and gender identity. 2022 updates to date. The Fair Housing Act itself does not specifically include sexual orientation and gender identity as prohibited bases. However, discrimination against an LGBTQ+ person may be covered by the Fair Housing Act if it is based on nonconformity with gender stereotypes. However, the HUD under the Biden administration stated that it would enforce the Fair Housing Act to prohibit discrimination on the basis of sexual orientation and gender identity. HUD has claimed this authority based on its interpretation that the Fair Housing Act's sex discrimination provisions are comparable in text and purpose to those of Title VII of the Civil Rights Act that bar discrimination based on this category. In accordance with this new policy, any state and local jurisdiction that received funding from HUD or HUD-sponsored programs must administer the Fair Housing Act to prohibit discrimination based on sexual orientation or gender. Likewise, any organization or agency that receives any type of funding through HUD or HUD-sponsored programs must administer the Fair Housing Act in the same way. Even beyond the new HUD mandate, the NAR Code of Ethics, Article 10, provides additional status protection for gender and sexual orientation, regardless of HUD's association. Realtors shall not deny equal professional services to any person for reasons of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors shall not be parties to any plan or agreement to discriminate against a person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Realtors, in their real estate employment practices, shall not discriminate against any person or persons on the basis of race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Finally, some states may have additional protected classes, so make sure to check the fair housing laws and regulations in your state. Modifications, accommodations for people with disabilities. The FHA requires two types of changes to make existing housing more accessible to people with disabilities. Individuals with disabilities must be allowed, at their own expense, to make reasonable modifications for the enjoyment of the premises. Premises apply to the interior of the unit of the individual with a disability, as well as lobbies, main entrances, and other public and common use areas of a building. Reasonable accommodations must be made in rules, policies, practices, or services necessary to afford an individual with a disability equal opportunity to use and enjoy a dwelling. An individual with a disability is responsible for the cost of modifications and must obtain approval for the modifications from the landlord. Housing providers do not have an absolute right to reject proposed modifications, nor select or approve who will do the work. However, a landlord may require a description of the work, reasonable assurances about the quality of the work, and that appropriate or required building permits will be obtained. In rental situations, the landlord may require, with some limitations, the renter to restore the premises to its prior condition. Restoration work can only be required where it is reasonable to do so. For example, making a door narrow again after it has been widened is not considered reasonable. The use of service animals has become more widespread in recent years in assisting individuals with various disabilities. While many people have valid reasons for the use of service animals and are protected under the FHA, some people have tried to take advantage of this protection by claiming a medical need when there is none. To help address this issue, HUD released new guidance to assess the validity of the need for service animals. As of 2020, landlords and property managers can require reliable verification of the tenant's need for an assistance animal and can require documents other than an online certification. Prohibitions of the Fair Housing Act. Refusing mortgage loans and/or financial assistance based on membership in a protected class. Discriminating in providing brokerage services. Refusing to rent a dwelling, whether outright or subtly, by using techniques to confuse or harass the applicant, and rescinding an offer upon learning of a person's protected status. Using discriminatory terms, conditions, or privileges in the sale or rental of a dwelling. Using discriminatory advertising, with respect to the sale or rental of a dwelling. Misrepresenting that a dwelling is not available for inspection, sale or rental when it is in fact available to any person of a protected class. Attempting to influence, for profit, someone to sell or rent a dwelling based on fears about entry into the neighborhood by a member or members of a protected class. This practice is commonly known as blockbusting. Denying the opportunity for sale or rental of a dwelling to people with disabilities. Coercing, threatening, intimidating or interfering with any person's exercise of his or her rights. Exemptions under the Fair Housing Act. There are some exemptions to the FHA, based on various types of living arrangements and affiliations with certain groups or organizations. The exemptions are outlined here. Single-family houses, if the owner owns, sells, or rents the house. Owns 3 or fewer homes at any one time. Does not use the services of someone in the real estate business. Does not advertise in violation of Section 804C house or living quarters that are occupied or intended to be occupied by no more than 4 families living independently, and the owner maintains or occupies one of the living quarters. Owner-occupied duplexes are eligible for the exemption. Religious organizations, associations, or societies can give preference to such persons if membership in the religion is not based on race, color, or national origin. Non-profit organizations or private clubs can give preference to their members when, in addition to their primary purposes, they provide lodgings that they own or operate other than a commercial purpose. Housing for older persons is exempt from familial prohibitions.